Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Welcome to another session of this course on Islamic inheritance law, in which we shall be looking at the inheritance from an apostate. Let's start off with text from the Sirajiyah. إذا مات المرتد على ارتداده أو قتل أو لحق بدار الحرب وحكم القاضي بلحاقه فما اكتسبه في حال إسلامه فهو لورثته المسلمين، وما اكتسبه في حال ردته يوضع في بيت المال عند أبي حنيفة رحمه الله تعالى، وعندهما الكسبان جميعا لورثته المسلمين، وعند الشافعي رحمه الله تعالى الكسبان جميعا يوضعان في بيت المال، وما اكتسبه بعد اللحوق بدار الحرب فهو فيء بالإجماع، وكسب المرتدة جميعا لورثتها المسلمين بلا خلاف بين أصحابنا، وأما المرتد فلا يرث من أحد لا من مسلم ولا من مرتد مثله، وكذلك المرتدة إلا إذا ارتد أهل ناحية بأجمعهم فحينئذ يتوارثون. A Muslim who leaves Islam is known in Islamic law as a murtad, that is, an apostate. In the law of inheritance, difference of religion is a barrier to inheritance. The Prophet ﷺ said, "A Muslim does not inherit from a non-Muslim, and a non-Muslim does not inherit from a Muslim." Based on this principle, an apostate does not inherit from a Muslim. Likewise, a Muslim does not inherit from an apostate. Two apostates do not inherit from one another. In the Hanfi school, special rules apply regarding the estate of an apostate, as we'll see later on. In other schools, including the Hanbali school, the dominant position is that difference of religion prevents inheritance between Muslims and non-Muslims, and the apostate is treated as outside the fold of Islam for inheritance purposes. According to the Hanbali school, if an apostate returns to Islam before the estate is actually distributed, he may inherit, because entitlement is considered at the time of distribution. Since he has returned to Islam before division, the barrier is removed. By contrast, many other jurists consider entitlement to inheritance to be determined at the moment of death. So if a person was an apostate at the time the deceased died, he would not inherit, even if he later returns to Islam. If a Muslim heir becomes a non-Muslim after the death of a relative from whom he is entitled to inherit, he is still entitled to inherit because when the inheritance devolved, he was still a Muslim. If a man dies, leaving behind a non-Muslim son and a son's son who is a Muslim, the non-Muslim son does not inherit due to difference of religion. Because he is legally excluded, the Muslim grandson may inherit in his place according to the rules governing residuary heirs. In the Hanfi school, according to Imam Abu Hanifa, the inheritance rules differ between an apostate man and an apostate woman. First, with respect to an apostate man, the Hanafis hold that when a Muslim man commits apostasy, he is treated, in legal effect, as though he has died at the moment of his apostasy. In other words, apostasy triggers a constructive legal death, hukmi death, in relation to his property. Accordingly, his Muslim heirs may inherit from the wealth he possessed up to the moment he apostatized. That estate is distributed among those who were his eligible Muslim heirs at that time. As for any property he acquires after apostasy, that wealth does not go to his heirs. Rather, it is allocated to the Bayt al-Mal, the public treasury of the Muslims. Now, as for an apostate woman, the ruling differs in the Hanafi school. The Muslim relatives of an apostate woman inherit her entire estate, meaning both the property she owned before apostasy and anything she acquired thereafter. While Imam Abu Hanifa distinguished between a male and a female apostate in matters of inheritance, his two foremost students, Imam Abu Yusuf and Imam Muhammad al-Shaybani, did not maintain this distinction. According to Abu Yusuf and Muhammad, there is no difference between a male and a female apostate. In their view, the entire estate of an apostate, whether man or woman, is inheritable by his or her Muslim heirs. They do not limit inheritance to the wealth owned prior to apostasy. Now, regarding lineage, if a man apostatizes while his wife is pregnant, any child born within 6 lunar months from the time of apostasy is attributed to him, because the minimum gestation period in Islamic law is 6 lunar months. As such, that child is considered legally his and may inherit from him if the other legal conditions of inheritance are fulfilled. Finally, according to the Maliki, Shafi'i, and Hanbali schools, Muslims do not inherit from an apostate at all. They apply the general principle derived from the hadith that a Muslim does not inherit from a non-Muslim, nor does a non-Muslim inherit from a Muslim. Based on this principle, they hold that the entire estate of an apostate is transferred to the Bayt al-Mal, the public treasury of the Muslims, and is not inherited by his Muslim relatives. This brings us to the end of this session. Insha'Allah, see you in the next one.